Welcome back to this week's episode of The Emily Show. Today we are breaking down the wrongful death lawsuit against Karen Read, and we have to talk quickly about what's going on in Idaho because there is a hearing coming up on Thursday this week on August 29th, and that is a pretty big hearing on the change of venue. So we're going to do a quick overview of what to expect there and then dive into that wrongful death lawsuit. Plus, we are still waiting on the Girardi verdict. So if you don't have the Lume Ad app, now's a great time to remind you, well, for me to remind you that that's where you want to be because that's where those updates are going to be put by me the fastest. Things go in the Lume Ad app before they go anywhere else. All right, let's get into today's episode. Welcome to The Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. A huge thank you to today's sponsor, Factor, the only way I've really been getting healthy meals while I've been covering the Corey Richins preliminary hearing on live stream, and having a balanced meal with protein and veggies that was ready to go in 2 minutes that had been delivered to my door was such a relief. It can help me meet my goals of eating more protein without defaulting to a choice I don't want to make just because it's easy. Factor has meals ready for you no matter what your wellness goal is, whether it's getting in more protein, going keto, or just looking for ready-to-go chef-prepared meals with fresh ingredients. Not only does Factor have over 35 different meals to choose from, but they have over 60 add-ons, including fresh juices, breakfast, dessert, and you have lots of options for premium ingredients like filet mignon, shrimp, and blackened salmon. So no matter what your life has going on, you don't have to shop, prep, cook, or clean up, and you can still have a chef-quality, healthy meal ready to go. So thank you, Factor, for making sure I get well-balanced meals even when life is not so well-balanced. And if you're ready to try Factor for yourself, head over to factormeals.com/EDB50. Use code EDB50 to get 50% off your first box plus 20% off your next month. That's code EDB50 at Factor Meals to get 50% off your first box and 20% off your next month while your subscription is active. Let's get back to today's episode. For a quick update in the Girardi fraud trial, as of the recording of this episode, knee-deep in the middle of the Corey Richins preliminary hearings in Utah, Girardi's jury is out on his wire fraud counts, the government alleging that he stole from 4 of his clients. Some of those clients are well-known, and what has happened to them has been really well established. Will the jury find those thefts to be wire fraud? Will they find that Tom Girardi knew what he was doing or not? We will see if that jury comes back before this episode airs and probably have an addendum at the end. And if not, then we are still waiting. But the 4 counts went to victims that we have seen, from the housewife and the hustler to the state bar charges against Tom Girardi for theft from clients. And the state bar laid it out real clearly, and so did the Rue Gomez family. They did not get their money. Tom Girardi's attorneys arguing that he's just a sweet old guy, y'all. And, you know, it wasn't him. There was fraud, but it was all the CFO. So they leaned all the way in to that empty chair defense. You know, the some other dude did it, or the Shaggy. It wasn't me. It's pointing at the CFO, who is not on trial at this time, but will be later. During the course of that trial, we also learned that investigators are looking into 4 other attorneys from that firm. 2 of those attorneys, David Lira and Keith Griffin, have already been indicted in Illinois. Will they be indicted in Los Angeles with others? We will see. All of that will bolster the ongoing and numerous civil litigations. The thing that's difficult with all of the civil litigation pending is that Girardi doesn't have the money, and neither does the firm. Will they be able to recover funds from other attorneys or Erica Girardi in the civil cases is yet to be seen. But what do we know for sure up on this channel? The government will get theirs. So those forfeitures, the government will be pursuing handily to get back monies for the victims of the 4 charges in this prosecution if Tom Girardi is convicted. Easier than those victims going after it civilly or going after it in the bankruptcy. But the bankruptcy, which is not done yet, is going to complicate all of that. No, Erica Girardi did not testify. Yes, behind the scenes of Real Housewives, unaired clips of Real Housewives were played in the trial, showing Tom Girardi interacting with Erica and others when the Housewives of Beverly Hills were at his house. And yes, her company, EJ Global, was discussed in this case. But again, she has spousal privilege. She is not on trial here. So while she was talked about, Erica Girardi was not actually at this trial, was not physically present, was not called to testify or anything like that. And it's Emily from Tuesday, August 27th. After recording with your addendum, Tom Girardi was convicted today of 4 counts of wire fraud. Those are all the counts before the jury. Tom Girardi is facing up to 80 years in prison, and we will learn much more about what the government is seeking when we get their sentencing memorandums. He will be sentenced in early December 2024. He is facing quite a lot of prison time. And what we learned from the Alec Murdaugh sentencing is that judges very much do not like attorneys that steal from vulnerable clients. Remember that the prosecution will also be able to bring in pattern of behavior evidence. So more than just the 4 charged clients, other clients who were not charged, other instances, and the bar complaints that go back decades. So if you are not caught up in all of the Girardi stuff, there is a whole playlist from when this case broke in 2020 to now, with some of the things that I'm sure the feds will bring into their sentencing memorandums when that pre-sentencing report is done. So we will see Tom Girardi back in court in December of 2024 for sentencing, likely to prison. The Bryan Kohberger trial, the court has indicated, is going to take maybe 4 months, and they are looking at a summer 2025 trial date for the quadruple homicide that Bryan Kohberger has been charged with in Idaho. The litigation in this case has been busy, just busy since the beginning of the case. Much of it sealed, some of it public. Some of it was sealed and then became public, and there was much fighting at the last hearing over that. The hearings have been very interesting. Judge, and yes, that is his name, Judge John C. Judge, really does enjoy the intellectual curiosity of it all. And sometimes those hearings go on quite a bit under the judge's questioning as well. I think he just enjoys chatting with the lawyers sometimes. The lawyers all look like they are ready to move it along. The hearing that is coming up on Thursday, August 29th, is a hearing for change of venue. The defense attorneys have been arguing about this for quite a while. And remember, there were those hearings in the middle where the prosecution was like, Your Honor, what? The defense is contacting the potential jury pool. The prosecution argued to the court, the defense is actually causing the problem that they are seeking to not cause by the questions that they are asking. The defense ringing people up and being like, so do you think Bryan Kohberger is guilty? Did you hear he might have followed one of the victims on social media? Did you hear this? Did you hear that? The prosecution said by nature of the questions, they are in fact causing the problem that they are saying exists. So they're going to cause the problem, then say, see, there's a problem, and then seek to move the trial outside of the county where Moscow, Idaho is. So there was a whole hearing in the middle about whether the surveys of potential jurors would be allowed to continue. The court allowed those to continue. The motion practice has gone on, and now we are coming to hearing. The defense saying, hey, per the surveys, there is no way we can have this trial in this county. The jury pool is hopelessly tainted by the substantial amount of public interest in news media here. We have to move this to a larger county where the case is not as well known. And the defense has been indicating that they want to move that to Boise and have a larger jury pool to grab from, and a jury pool that might not have been as tuned into national media. Could this backfire on them? Yes, because they have said, Your Honor, this case garnered international media. And so the prosecution, we may see arguing, well, Your Honor, if there's international media, there is no county that's not heard of it. So we should just leave it here in Moscow. This community has a deeply vested interest in this case. You know that the fight over cameras in the courtroom will come up at some point with all of this, because the prosecution is going to say this community is invested. They need to be present. And the court is going to say anyone can be present because they can watch it via stream. The court's already taken over streaming in that case. They've kicked out any pool cameras and said, we're just going to stream it directly to our YouTube channel and we'll control the cameras. It's like C-SPAN in Idaho. So the court will have that option. But of course, we'll see the prosecution saying that moving it is deeply inconvenient for those connected to this case, for the victims' families, for the victims' friends, for the college community, and for witnesses. So will the court grant this change of venue? Could or could not. It's really going to depend. If the court thinks that everyone has been exposed to the media in this case, then there is no point to move it, because there is no place to move it within the state of Idaho that is less aware. And then you have to solve the issue with very narrowly tailored and very specific jury questions in voir dire. But remember, even if this gets denied by the court, you can get into voir dire, because the prosecution's also arguing this is premature. You can get into voir dire and start getting questionnaires back from jurors and go, so Your Honor, now we actually can't pick a jury pool. We've sent out 900 questionnaires or whatever they're going to end up sending out, and we're getting them back, and everybody is responding that they can't be open-minded about this case. And we saw that happening in the Murdaugh second financial crimes case ahead of that case pleading. We saw Murdaugh's attorneys undergoing jury surveys and coming into court saying, okay, well, now we need to change venue. Here are all the surveys indicating that jurors were tuned in to the Murdaugh murder trial. And because they were so invested in that, they can't separate what they learned in the murder trial from this financial crimes case. And they waited until the surveys were being done. Could this judge kick this down the road and say, you know what? All of this has been fascinating, but I agree with the prosecution. It is premature. We need to survey the jurors first and then decide. He absolutely could do that. Has this judge pushed decisions off and down the road somewhat frequently? Yep, sure has. So will we see this decided on Thursday? Absolutely not. We will absolutely not see any decision at the end of Thursday's hearing. This is going to be taken under submission probably for quite a while, and the court could punt till later and say, you know what, we really do need the jury surveys. The theory is all great, but until we really get down to brass tacks, we're not going to know. And that puts all of the counties in a bad position, because the case is already pushed out till summer 2025. The prosecution's already kicking a bit about how far out this case has gotten pushed. And the defense is still saying, Your Honor, I don't even know if we're going to be ready by summer 2025. So the judge might say, you know what, let's start surveying the jury ahead of the trial. And if we have to move it and change venue, then it's probably going to kick that case out another 8 months. But the defense is not arguing that this case needs to go to trial faster. The defense at this point wants a lot more time. Remember, it is terabytes of data that they're going through, and they're still fighting over discovery. And that, I'm sure we'll hear a little bit more about in the hearing on Thursday. Again, the Lawnerd app is where you stay in the loop on that. We need to go from Idaho to Massachusetts. Chat was like, we had to play the bumper. And I was like, we did. And for those of you saying, what do you mean, chat? We record quite a lot of the podcast episodes with our members. And so chat was like, but we need EDB Air. So for the video crew, you got that. If you're listening on audio only, you're going to have to go to YouTube. And then you can see our beautiful EDB Air bumper. Let's talk about the Karen Read case. We know that the court has denied Karen Read's motion to dismiss. The defense has vowed to appeal. Well, of course they will. That is going to wind through the courts. The Karen Read case is set to go to trial in January 2025. So actually, before the Kohberger case, we might get 2 Karen Read trials before Kohberger ever goes to trial. So we'll see. But as we get further along and as we see the appeals and what the appellate court may or may not do, we'll have a better understanding of whether or not this will actually go to trial. I really don't see the defense putting their foot down and saying, no, make this go to trial. I see the defense fighting forward to get this appeal done before it ever goes to retrial. And I think that's probably in all of their best interest. But While the criminal case is winding its way through appeals and back to a retrial, we now see a wrongful death lawsuit. We have seen this in other criminal cases. The one you probably remember, if you're in my audience, is the O.J. Simpson case. There were wrongful death suits where O.J. was found liable for the wrongful death of Nicole Brown Simpson and of Ron Goldman. And then everyone fought over the money forever and ever to try to recover from those wrongful death lawsuits. But he was acquitted in the criminal trial. So yes, you can have civil liability when there is not criminal liability. The standards are different. It is lower. You don't have to have a unanimous jury in most jurisdictions. These things can settle out of court. So there are lots of factors that play in here. And we saw how much a wrongful death lawsuit played into the Murdaugh case when we were looking at that Mallory Beach lawsuit, and how much the Mallory Beach lawsuit and the discovery in the Mallory Beach lawsuit was not just pushing on Murdaugh, but was pushing on the gas station that had sold liquor to Paul Murdaugh and others. The discovery becomes a large and critical part of any civil wrongful death case. And there are things in the wrongful death case that the family may be able to obtain that they don't have from the criminal case, or that they've not been given from the criminal investigation because that case is still ongoing. I wonder what John O'Keefe's family will unearth from any federal investigations, and I wonder if it will be helpful here or not. Let's take a look at who's being sued, what they're being sued for, and what is being alleged. Thank you to today's sponsor, Lume. It is that time of year for me when my kids are back in school, but it is still so stinking hot outside. But that doesn't stop me from working snack bar duty at the high school football games to support the band. So I make sure that I am rocking my Lume whole body deodorant so that I know no matter how hot it gets inside the snack bar while people are pumping out nachos, that I am covered. One of the things I really like about Lume whole body deodorant is you really can use it from your pits to your feet and all of the bits in between. If you've not tried Lume yet, the Lume starter pack is perfect for new customers because you get a deodorant stick and a tube of deodorant. Plus, you can choose 2 free products of your choice, like the deodorant wipes that I love and the body wash that further supports breaking down that body odor. So you can start with your cleansing in the shower and carrying it all the way through using your whole body deodorant. Plus, you get free shipping. So as a special offer for our listeners, new customers get 15% off. And if you combine that with the discount of the bundled starter pack, that's over 40% off. So use code LAWNERD to get 15% off your first purchase at lumedeodorant.com. That's code LAWNERD at LUMEDEODORANT.com. Let's get back to today's episode. So first up, this was filed in Massachusetts in Plymouth County on August 26, 2024. This is Paul O'Keefe suing as a personal representative, or a PR, of the estate of John Joseph O'Keefe III. Paul O'Keefe is also suing individually, so on his own behalf. Margaret O'Keefe is suing on her own behalf. John O'Keefe II, the victim's father, is suing on his own behalf. And then Margaret O'Keefe is suing as the grandparent and guardian of Kaylee, John O'Keefe's niece. They are suing as a group, C.F. McCarthy's, the Waterfall, and Karen Reed. So the hospitality companies that are doing business as those bars. I'm going to refer to the bars C.F. McCarthy's and the Waterfall as that because that's how we know them from the trial. And I'm going to do my best to not say C.F. McCarthy's, but I can't promise you it's going to go well with me trying not to say it after listening to this trial for 9 weeks. They go through parties and jurisdictions. They talk about who everyone is. We know who these parties are. I am not going to go through it, but again, Paul is suing on behalf of himself and behalf of the estate. Margaret, John O'Keefe's mother, is suing on her own behalf and on behalf of his niece, who he was taking care of. Let's get right into the facts. Plaintiff repeats, realleges, and incorporates by reference everything set forth here too. So all of the parties, jurisdiction, who everybody is. Decedent JJ, which is what they are calling the victim, John Joseph O'Keefe. The decedent JJ was the middle of 3 children in a tight-knit family. JJ was a 3rd-generation Boston police officer. After the tragic death of JJ's sister Kristen and brother-in-law Steve, JJ took custody guardianship over his niece Kaylee and nephew Patrick, who were 6 and 3 respectively. Over the next 8 years until his tragic passing, JJ raised and supported his niece and nephew. And yes, they are suing on behalf of the niece. The nephew is not mentioned. I don't know why they've made that choice, but that is a choice that was made in this lawsuit. Could there be another lawsuit? Maybe. But I don't know if there is a reason they did that, if the nephew chose that, or if that is a quirk of law in Massachusetts that allows for just one beneficiary to be sued for. They go on to say, at all relevant times on or before January 29th, 2022, JJ and defendant Reed were in a dating relationship. In the months, weeks, and days leading up to January 22nd, JJ and defendant Reed's relationship was deteriorating. During such time, defendant Reed picked fights, experienced jealousy, and had delusions of unfaithfulness. Well, they're definitely not holding back on that. On or about January 28th, defendant Reed knew that the relationship with JJ had run its course. I don't know how they know that, but we'll be interested in seeing how they try to prove that up in discovery. Law enforcement already has all the cell phone dumps, so they're going to have all the text messages. And then the testimony we didn't see from the niece and nephew about the fights that John and Karen were having leading up to this, the niece and nephew will know that as well. On January 28th, on or about 8:51 p.m., plaintiff arrived at CF McCarthy's. CF McCarthy's was licensed to distribute, sell, or serve alcohol. On January 28th at about 8:58 p.m., CF McCarthy served Reed an alcoholic beverage. Reed consumed said drink. I think they're going to go through what we saw at trial, and we saw timestamps at this. This is one of the things that Lally actually made clear in the criminal prosecution. Lally went through the videotape from CF McCarthy's and stopped it at different points, showing when Karen Reed had consumed what they said was alcohol. We didn't see a ton of the receipt. The jury had it. We didn't see it. So there was some discussion like, well, this could have been just club soda in a shot glass, or this could have been this or that. This will all bear out in the civil case. There's video, there's a receipt. There will be a bartender who will be like, no, those were shots of vodka or what have you. And the jury, at least from everything we've seen in the litigation subsequent, thought that Karen Reed had been drinking based on the fact that they were leaning towards guilt on those lesser includeds of the DUI count. On January 28th, CF McCarthy's, I can't help it. I can't help it. Look, man, we're just feeling the Boston re-enter my soul. My freshman year at UMass is rearing its head, and that's where we're at. And they allege that the bar, through its agents, servants, employees, etc., and that is all just legal language for everyone who works there, served alcoholic beverage to defendant Reed at or about 9:13 p.m., 9:20 p.m., 9:33 p.m., 9:57 p.m., 10:22 p.m., and 10:29 p.m. They allege that Reed consumed such drinks. It goes on to allege that CF McCarthy's, through its agents, employees, served defendant Reed 7 alcoholic drinks between 8:58 and 10:29 p.m. During all relevant times, at or before 10:29 p.m., defendant Reed showed signs of intoxication while at CF McCarthy's. For all of you that watched the trial, you saw the video, you can decide for yourself. On January 28th at about 10:40 p.m., JJ and Reed left McCarthy's, and defendant Reed was allowed to carry her alcoholic drink out of CF McCarthy's. I don't know if she was allowed to. She seemed to smuggle it in her jacket. I don't know if that was, they didn't tackle her. She was able to carry it out. I don't know if that was permissive or she was just like yoink. At or about 10:54 p.m. on January 28th, defendant Reed and JJ entered the Waterfall together. At all relevant times, the Waterfall was licensed to distribute, sell, and serve alcohol. Reed walked into the Waterfall carrying a drink from CF McCarthy's. How many times is this going to say at a high top table? Maybe none. Wouldn't that be lovely? But we all now know intimately, without ever being there, or at least most of us without ever being there, the interior layout of the Waterfall, because we have seen videos from this bar so many times. They go on to allege that we are now after midnight, and at all relevant times on January 29th, while at the Waterfall, Reed showed signs of intoxication. Between 10:54 p.m. and 11:54 p.m., On January 28th, the Waterfall served Reed one shot and one mixed drink. Reed consumed the drinks. At approximately 12:10 a.m. on January 29th, Reed left the Waterfall. At approximately 12:11 a.m., JJ left the Waterfall. Between 12:11 a.m. and 12:36 a.m., defendant Reed was under the influence of alcohol and unable to drive a motor vehicle safely. This is their wrongful death suit, but she was not the only one. There was so much DUI that night. It goes on to say at all relevant times on January 29th, defendant Reed drove JJ to the residence at 34 Fairview. Defendant Reed and JJ had been in an argument the night of January 28th into the morning of January 29th. After JJ got out of defendant Reed's vehicle in front of 34 Fairview, Reed drove her SUV and hit JJ. I don't know if they're going to get into that more, but we'll see, because it seems that this is what the family thinks happened. Many have asked, how does the family feel about this? How does the family feel about Karen Reed? And we are seeing some of it in this wrongful death lawsuit. It goes on to say at all relevant times on January 29th, Reed drove her SUV in a state of intoxication. As a result of Reed hitting JJ on January 29th, JJ was knocked down onto the ground in front of 34 Fairview, suffered serious injury, and died. There are still, from watching this trial, so many questions in this case. I don't know if the family will get the answers that they deserve and that they desire through this wrongful death suit, but I hope that they do. I still have so many questions about how he ended up all the way back by where the fire hydrant was if he was incapacitated at the curb line. There are so many questions here, and these allegations are really what you expect to see in a civil lawsuit. It's just the kind of basic or more bare bones allegations of what happened. They go on to say that after hitting John O'Keefe with her SUV, defendant Reed fled the scene and returned to JJ's residence at 1 Meadows Ave. At all relevant times, Reed knew it was snowing, knew there was an impending blizzard. There's the snowing, knew or should have known that leaving JJ outside in a blizzard would likely result in serious injury or death. At all relevant times when defendant Reed drove her SUV and hit JJ, Reed failed to use care and avoid creating an unreasonable risk of harm to the public and to JJ, voluntarily took obvious risks under the circumstances, knew or should have known that death or serious injury was reasonably practicable, persisted in a clear negligent course of conduct over a noticeable period of time, was impatient with reasonable precautions, was deliberately inattentive to the predictable hazards of her actions, and was deliberately inattentive when there was a risk of great and immediate danger. They go on to say that at all relevant times when she drove her SUV and hit John O'Keefe, she was reckless when she intended the reckless conduct. That is a bold allegation, that she intended conduct that resulted in John O'Keefe's death, that her conduct made it highly likely that someone, namely John O'Keefe, would suffer serious injury or die. She had reason to know. So this is all the different standards they're alleging. They've gone from the highest standard, intention, to highly likely, to known or should have known, to unreasonable disregard of the risk. So they've gone through all of the different levels of liability there. They say that John's injuries or death resulted from defendant Reed's decision to engage in the conduct referenced above, the drunk driving. It goes on to allege that on January 29th at 4:30 a.m., defendant Reed knew she hit John O'Keefe with her SUV. Nevertheless, she woke up John O'Keefe's 14-year-old niece, Kaylee, and talked about John O'Keefe's death, talked about hitting John O'Keefe with her SUV, and otherwise involved Kaylee in her frantic calls about John O'Keefe's death. At all relevant times, defendant Reed knew Kaylee was a vulnerable minor who already lost her parents tragically and depended on her custodial uncle, John O'Keefe, who became her surrogate parent. I wonder if that is going to go to pain and suffering allegations. On or about 5:07 a.m. on January 29th, Reed left 1 Meadows Avenue. Between 5:18 and 5:35 a.m., Reed knew John O'Keefe was seriously injured, buried in the snow, and lying on the ground in front of 34 Fairview, where defendant Reed left JJ to die hours earlier. They continue to say that defendant Reed admitted repeatedly that she hit John O'Keefe. So they are leaning into those statements that we saw presented at trial, the I hit him statements. I can only imagine that's what this lawsuit is alleging. It goes on to say at 6:03 a.m. on the 29th, Reed arrived at 34 Fairview and immediately observed JJ lying on the ground, buried in snow where she had earlier left him to die. that JJ suffered traumatic injuries before becoming hyperthermic. On or about 7:50 a.m. on the 29th, JJ was pronounced dead at the hospital. At relevant times after 7:50 a.m. on January 29th, defendant Reed went to the grieving house of JJ, feigned comfort to JJ's family, and used the opportunity to, amongst other things, remove the offending weapon, her vehicle, and or destroy relevant evidence. So they are not happy with her at all. And while these aren't the most scathing allegations I've ever seen in a lawsuit, they are making it strongly known that they did not believe that she was showing up back at One Meadows to grieve with John's family, that she was doing it to essentially take things out of the home and clear the weapon out of the home. It goes on to allege that on January 29th, defendant Reed's blood alcohol draw conversion would have shown a BAC between 0.13 and 0.29 around the time she drove the SUV and hit John O'Keefe. Again, when this goes through the process of civil, yes, there will be a fight over retrograde extrapolation. This is just the complaint. This is how they are showing they know enough to bring a wrongful death action, and alleging that at the time of driving, her BAC would have been between 0.13 and 0.29 is based on the state's evidence at trial. They say that the BAC of 0.13 to 0.29 exceeds the limits to drive a motor vehicle in Massachusetts. Yes. They allege that she drove her SUV under the influence of alcohol when she hit John O'Keefe. They allege that as a direct and proximate cause of the drunk driving, John O'Keefe sustained serious injuries of body and mind, conscious pain and suffering, fear of impending death, lost earnings, medical, funeral, and burial expenses, and died. So that is the whole segment of like the heart of the civil lawsuit for the estate of John O'Keefe. I imagine John O'Keefe's estate will end up going to his niece and nephew. So what is recovered for his conscious pain and suffering, fear of impending death, loss of earnings, injuries, that will all end up ultimately going to his niece and nephew, as it should. I'm interested that they're bringing this next part up in this lawsuit. The suit goes on to say, notwithstanding her Fifth Amendment right not to speak, defendant Reed chose to speak publicly. She knowingly and deliberately changed her story and fabricated a conspiracy, knowing the same to be false. She publicly communicated this false narrative, thereby frustrating justice for JJ. Such false narrative caused the plaintiffs aggravated emotional distress. So they are asking for the emotional distress of Karen Reed telling the public that she did not hit John O'Keefe. I wonder how that will go legally when they come down to this. But this next allegation before they get to the counts shows exactly why they're bringing this complaint. They say the plaintiffs listed above bring this complaint seeking full and complete justice for JJ, and that is all in caps. Well, for anyone asking from here forward, how does John O'Keefe's family feel about all this? I think this civil lawsuit has made it quite clear. I wonder if the establishments that were providing drinks for Karen Reed will settle this lawsuit for the estate. The thing is, I don't think anyone, no matter what they believe about what the state showed in their case, I don't think anyone disagrees that John O'Keefe's family deserves answers, that John O'Keefe's family deserves justice, and that the investigation here was appalling. It was appallingly bad. I can't imagine the frustration of the family. And while that frustration seems to be pointed largely at Karen Reed, there has to be frustration towards law enforcement and investigators as well. But this is a generational family of Boston PD. I wonder how much the federal investigation is going to impact how they feel about that. This investigation was not good. They did not bring law enforcement into this civil wrongful death suit. There are complications and excessive complications with doing that. There are also some hurdles before that can be done, with notice that needs to be given if you're suing the government, etc. Could that happen in the future? I wonder if it may when we see the results from the federal lawsuit. I wonder if that could happen down the road. Right now, this is pointed at the establishments serving alcohol and at Karen Read. But I wonder if when we get to the end of the investigations and the federal investigation, whatever it may be, I just wonder if we will have more information, because at the end of trial, there was not a clear answer for me after sitting there watching 10 weeks of trial. And I can't imagine how frustrating that is for everyone involved. And you've got two families and an entire community at odds, not just a little bit, but in such a vitriolic way that it also has spilled over into social media, not just nationally, but internationally. It's incredibly unfortunate because it sticks the kids who have lost their mom, their dad, and their caregiver uncle in the middle of a very vitriolic shitstorm without a lot of answers about what actually happened to their uncle, and without the people who should have found those answers doing their job, and instead getting in text message groups with their high school buddies. And I love a text message group with my high school buddies, but getting into a text message group with their high school buddies, name calling the defendant, Karen Read, from the second this investigation started. How did they ever think a jury was not going to look at that as a tainted investigation? And that's the least of it. The name calling is the least of it. Thank you to today's sponsor, Honeylove. And even though I am very ready for the weather to change, it's not necessarily time to put away those summer dresses just yet. So no matter what your needs are, Honeylove has got you covered. And one of the things I always tell you not to sleep on is their sleepwear. And yes, Honeylove is like, talk about our shapewear. I'm like, the shapewear is great. The law nerds know it's great, but the sleepwear, the cooling sleepwear, as the nights continue to be hot and it is cooling, it holds everything in place. It is my absolute go-to. And I wear the sleepwear not just to sleep, but even for getting ready in the morning, because it keeps me cool and it is just that comfortable. So whether you are looking for their best-selling power short to go under your favorite dress, or the bras as the weather starts to change, because nobody wants pulling and bunching and bulging when they're wearing their favorite sweater, or sleepwear to keep you cool, Honeylove has got you covered, and I've got a discount for you. Treat yourself to the best bras, shapewear, and sleepwear on the market and save 20% off at honeylove.com/lawnerd. You can use our exclusive link down below and get 20% off at honeylove.com/lawnerd. And after you purchase, they'll ask where you heard about them. Be sure to give the love to me and to the show. Let's get back to today's episode. Back to this complaint, we have gotten to count 1, which is the estate of John O'Keefe against C.F. McCarthy's for wrongful death. It realleges everything up above, talks about the fact that overserving a clearly intoxicated person is an issue. They are going to pull those videos again and take a look at whether Karen Read seemed visibly intoxicated. Here's the thing that's going to make these counts difficult for the estate of John O'Keefe is that the prosecution in the criminal trial against Karen Read asked every single person that was with them that night, did Karen Read seem intoxicated? And every single person, including those that had no love lost for Karen Read, said no. Not a single person. And all of them testified about where they sat at the basketball game, where they sat at the high top table, from families who seemed to loosely know everybody, like the Kolakithases, who were a delight in their testimony, to some of John O'Keefe's close friends, who you imagine don't have any love lost for Karen Read, to the families that are connected to 34 Fairview, who definitely don't have any love lost for Karen Read, all said she did not seem intoxicated. Every single person. That is going to make these civil counts against the bars very difficult, because the bars are going to pull up the transcript of the trial and be like, okay, so every single witness here says she didn't seem intoxicated. It doesn't mean the bars might not settle as positive PR, being like, you know what, this is going to the estate of John O'Keefe, hoping it's going to his niece and nephew, and making sure that that is handled. They might choose to do that, but I don't think they have to, based on all the testimony we saw at trial. I don't know how that's on the bartenders when everyone who knew Karen Read said she didn't seem intoxicated. She wasn't falling over. She wasn't being held up. She wasn't stumbling into tables. Count 2 is the estate of John O'Keefe versus the Waterfall. Same thing, wrongful death, alleging the overserving of Karen Read. Count 3 is the wrongful death between the estate of John O'Keefe against Karen Read, saying that on the date of the crash, defendant Read owed John O'Keefe and the public at large a duty not to drink and drive, to drive her vehicle safely and with due care. On the date of the crash and at all relevant times, it says Read owed John O'Keefe and the public at large a duty to pay attention to the roadway, to not drive in an unsafe manner, to not drive drunk, and that as a direct or proximate cause of Read's negligence, gross negligence, and or willful, wanton, reckless disregard for the safety, John O'Keefe sustained serious injuries of body and mind, conscious pain and suffering, fear of impending death, lost earnings, medical, funeral, burial expenses, and died. Some of the testimony at trial is going to make this difficult too. The federal investigation hired reconstructionists and biomechanical engineers, and the defense brought in expert coroners who all looked at the pathology of John O'Keefe and said, this doesn't really match with the way this would have gone down with a car. So there is evidence from the trial that is going to make some of this difficult. They are saying that as a result of Karen Read's negligence and wanton disregard for the safety of John O'Keefe's next of kin suffered as well. And the next of kin are entitled to John O'Keefe's lost value resulting from his wrongful death. If you want to talk about some of the weirdest stuff that you go through in law school, one of the hardest things to wrap my head around was when we were talking about these types of civil cases and portioning out the value of a lost life, how much value that life had, potential future earning expenses. It's a really weird thing to go through. I have never worked in plaintiff's law. I did criminal and I worked with judges, but even in working with judges, going through these calculations just seemed so strange to me. But these are the calculations that happen. They are fairly cold calculations. There are charts and graphs and things that look at the average age, the relative health and well-being, the earning potential, and all of these things. But it's just a very strange thing to talk about somebody's lost value. It goes on to say, wherefore the estate of John O'Keefe demands judgment against the defendant Karen Read on count 3 for all damages to which the estate is entitled. Compensatory and punitive damages, lost value to next of kin, and other relief the court deems appropriate. Count 4 is Margaret O'Keefe, John's mother, versus C.F. McCarthy's for negligent infliction of emotional distress, alleging that Margaret, the mother of John O'Keefe, learned of John O'Keefe's admission to the hospital immediately and came upon John O'Keefe's body at the hospital shortly thereafter, that the negligence of the bar caused the death of her son, and she suffered severe and profound emotional injuries manifesting in physical symptoms as the result of observing her son at the hospital and witnessing the consequences of the negligence of the bar. It then goes on to count 5, which is John O'Keefe Sr. against C.F. McCarthy's for the same negligent infliction of emotional distress, alleging the same thing. Count 6 is Paul O'Keefe versus C.F. McCarthy's for the negligent infliction of emotional distress, alleging the same thing that his mother and father did. Count 7 is Margaret O'Keefe versus the Waterfall for negligent infliction of emotional distress, again, alleging that the bar overserved Karen Read and that caused her distress. If any of this is found and there's going to be a fight over this, NIED claims for the mother, father, and brother of John O'Keefe. But this all gets into very large conversations about if anybody is liable, how does this all get portioned, et cetera, et cetera. So there are going to be 3 counts here, one for Margaret O'Keefe, one for John O'Keefe Sr., and one for Paul O'Keefe against the Waterfall for negligent infliction of emotional distress. Count 10 is Margaret O'Keefe versus Karen Read for negligent and or reckless infliction of emotional distress, again saying that Karen Read is the proximate cause of John O'Keefe's death. John O'Keefe's death caused the distress, but wait, there's more. Margaret suffered severe and profound emotional injuries manifesting in physical symptoms as the result of observing John O'Keefe at the hospital and witnessing the consequences of Reed's negligence. Defendant Reed outrageously created a false narrative. We talked about this more when we were looking at the Florida statutes about what that outrageous behavior is. When we looked at the Gabby Petito Brian Laundrie lawsuit, the civil lawsuit between the parents, where we saw Gabby Petito's parents suing Brian Laundrie's parents. It is not lost on me that I am recording this on the 3-year anniversary of Gabby going missing. It's something we saw alleged there where the Petito family sued the Laundrie family for not just statements they made, but statements they made through their lawyer. So I'm not surprised that we are seeing these intentional or reckless and negligent infliction of emotional distress causes of actions over the things that Karen Reed said. We saw that in the case in Florida, and we're seeing that now here. Are we going to see this more in the future? I don't know. Maybe. But in the Petito Laundrie case, the court never really got to take up whether this was an appropriate use of intentional and negligent infliction of emotional distress because that case settled and the settlement is confidential. But we are seeing Karen Reed being sued for the quote, outrageous false narrative. And then they are going on to allege the emotional injuries against John O'Keefe's mother, father, and brother, because there is one count for each of them suing Karen Reed for the same thing. Count 13 is the niece of John O'Keefe suing Karen Reed for negligent, reckless, and intentional infliction of emotional distress. This is a much different count. This count goes to Karen Reed waking Kaylee up in a panic, talking about where John was and the distress that that would have caused and did cause to John's niece. I think this is a very, very different cause of action for intentional infliction of emotional distress or negligent infliction of emotional distress than it is as to John O'Keefe's mom, dad, and brother. Here it alleges that at all relevant times, Kaylee was the niece of John O'Keefe. John O'Keefe was her guardian since her parents both passed away. Kaylee learned of JJ's death or injury when defendant Reed woke her up at 4:30 in the morning on January 29th. Defendant Reed knew Kaylee was vulnerable, having already lost her parents at the age of 6. Nevertheless, in Kaylee's presence, Reed spoke on speakerphone to various people between 4:30 and 5 a.m. on January 29th. At all relevant times on January 29th, Kaylee heard the defendant say, JJ never came home. Maybe I did something. Maybe a snowplow hit him. Maybe I had hit him. Maybe I hit him. We were in an argument. Maybe he got hit by a snowplow. As a result of the conversations defendant Reed had in her presence, Kaylee perceived the injuries caused to her guardian, Uncle JJ, and perceived the injury producing event. I'm going to start getting mad here. Because then not only did Karen Reed have this conversation with the teen was home alone other than Karen being there. And then Karen left, woke her up, freaked her out, and then left. That pisses me off. On or about 5 a.m. after waking up Kaylee and informing her that something happened to JJ, defendant Reed left Kaylee home alone. So, for me, as to the niece, this is the stronger intentional infliction of emotional distress cause of action. When you're looking at all of them, and it was clear that Karen Reed was panicked, absolutely panicked. But of all the intentional infliction and negligent infliction, NIED and IIED causes of action, I think this one is the strongest. And I imagine that all of those statements that they have grabbed for this civil lawsuit come from exactly what was testified to in trial, and there will be transcripts to back those up, but also from the conversations I'm sure Kaylee has had with her family members and her surviving family being John O'Keefe's mom, dad, and her other uncle and aunt. They say that defendant Reed intentionally or recklessly inflicted severe emotional distress when she woke up Kaylee and informed her that she hit her uncle, or that maybe a snowplow hit her uncle, that she knew or should have known that emotional distress was likely the result from her conduct. I mean, I don't think Karen Reed was exactly thinking straight, but I think when you get into, if this ever went to a jury trial, when you look at a vulnerable teen versus Karen Reed, the empathy there for a jury is going to be looking at, but you're the adult, even though Karen Reed was terrified. But the testimony at trial also showed that Karen Reed knew that John was always in touch with his niece and nephew because of how concerned they were that something would happen to him after losing their parents. And then we get all those text messages from Karen Reed to John O'Keefe's phone. You've left your niece and nephew alone. They're not here. I've left. And those text messages in this context, in a civil case, are not going to go well. But it's going to be really hard for Karen Reed to settle just this count, even though she may want to, without dealing with the rest of it. But those text messages aren't going to be great if this ever went to trial a million years down the road from now, because it's going to have to go through motions to dismiss and discovery and the rest of it. And the bars will likely try to settle out of it. And then you'll end up with this family versus Karen Reed, this potentially being one of the stronger cases or one of the stronger counts of action. They allege that Karen Reed's conduct was extreme and outrageous beyond the bounds of decency and was utterly intolerable. This is going to be the statutory language for that IIED and IED claim. And we see that language echoed across most of the jurisdictions in the US. It says, then, after JJ was declared dead, Reed came to the family home and feigned concern. Rather, it became clear that defendant Reed was only there to collect her belongings and take possession of the murder weapon. The emotional distress suffered from Kaylee was severe and of a nature that no reasonable person could be expected to endure it. Defendant's extreme and outrageous conduct caused Kaylee aggravated emotional distress manifesting in physical symptoms. Kaylee also suffered severe and profound emotional injuries as the result of perceiving JJ's death or the injury-producing event, the consequences of Reed's negligence. They go on to say, then Reed outrageously created a false narrative. And then they go on to illuminate further statutorily the injuries caused to Kaylee and the severe and profound emotional distress. Plaintiffs demand a trial by jury on all counts, and that is the end of that lawsuit. In all of it, I think this is a family seeking answers that they do not have, seeking discovery that they do not have, and they say in their lawsuit, seeking justice for John O'Keefe. I wonder if we will see any litigation against law enforcement. I don't know if we will. We have seen wrongful death cases be successful where people have been acquitted. The evidence here, I think, is more difficult given the expert testimony at trial. I think the causes of action against the bar are going to be difficult in light of the testimony that we've seen. I think it'll get past a motion to dismiss and get into discovery, which might be what they want. I think the cause of action as to the niece might be one of their stronger causes of action and likely the type of cause of action that will get settled. We don't see the nephew included here, but they did bring causes of actions for the estate. And one would hope when they include the loss of support, that those encompass both the niece and the nephew, because the only direct cause of action to the niece was the IIED. And overnight, the nephew was not home. He was at a friend's house, we learned, based on testimony and trial. So they have very much laid out that they are not happy with Karen Reed. They think the bar's overserved her, and they are going to be pursuing this. If you are interested, I will keep up with this civil litigation. Remember, civil litigation can take years. It's not dependent on any outcome in the criminal litigation, but everything that happened in the criminal litigation will inform this. The witnesses used there, the statements made, the videos shown. It's going to be good for the bar to say, hey, every single witness said she was not intoxicated. Her BAC said that she was, but there will be fights over the retrograde extrapolation, and the bartenders don't have a breathalyzer that they're giving to people that are ordering drinks at midnight. They're looking at the objective symptoms, and all of the witnesses said they did not see those. So this is not going to be a clear or easy civil lawsuit, The clear message here is that the O'Keefe family is not happy with Karen Read, believes that her narrative was outrageous, that it was a conspiracy, and that she has done inextricable damage to their family. At the end of the day, we will see what happens. Keep up with everything I'm doing in the Law & Order app because there is a lot of court to come in the next 2 months, lots of trials on the docket, and you don't want to miss a thing over on the YouTubes. So thank you for being here. Thank you for being a Law & Order. Thank you for staying in the loop with everything I'm doing. And we will talk to you in the next one. May your Wi-Fi be strong. May your toilet paper be plentiful. May your family be well. May the odds be ever in your favor. May your pumpkin spice be as spicy as the books I am currently reading. And I will talk to you soon. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com or search your app store for Law Nerd. And you can also follow me on social media at the Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, the Emily Show drops on Wednesdays. Thanks for being a Law Nerd.